All right, so let's get started. Not too much to report. Things are pretty much going along the way that they have been for the last couple of weeks. We've got a few questions, so let me take those and then we can open it up and take questions from everyone. So, first question: how many claims are being submitted per week? It's really hard for me to tell. I don't know the answer to that. Again, the goal is to have 500 in by October 1st. So we'll see how that goes. If we're able to meet it, then that'll be great. If not, we'll keep ramping it up. But we'd like to get everything submitted by the end of the year. I don't know how realistic that is, simply because I don't think everyone will have their documents in. But that is the goal, and that's the current close date for the portal. I think they'll keep it open longer than that. They'll extend that date, but that's where we are right now. Number two, do you have any projections for when the claims trustees will have accumulated the necessary preliminary sampling in order to assess estimated payouts versus claims? No, we had another TOC call today, but there's no more information. We hope it's going to be November, December, but we'll just have to wait and see. Number three, at what point do the PG&E stockbroker advisors begin to advise the judge, who is the trustee, to sell shares of stock in PG&E? We've had some preliminary calls and they've talked about that. I think the general consensus right now is we're not going to sell. The stock, when I last checked, which I think was last week, was about 9.5, which is up from where it was when we first received the stock, but it's still not where we need it to be. So the sense of everyone on the TOC is to wait, get through the first part of next year, and hopefully by that point, because we will have gotten through fire season and because the first quarter earnings will have come out, it should be much higher. And so that's the goal. But right now, I don't think there's any appetite to sell at 9.5. How will the expenses for our individual cases be handled? Experts, costs, etc. So that's a good question. Those are, we put them into the trust. They add them into the total amount, and then they're deducted from the ultimate amount. So if, for example, your individual costs were $5,000, then those would be taken out of the final amount that you receive. And the last question we have is, what if the stock does not get to $14 per share? Obviously, that is the danger. If it doesn't, then it means that the total amount will be less than $13.5 billion. Certainly, we hope that it gets above $14 a share, but if it doesn't, then the total amount will be less than that, and it may result in people getting less. Right now, we don't know what the total amount will be or what all the claims will add up to. Some people were projecting 10 billion, some people were projecting 15 billion. So we'll just have to wait and we'll see what happens. So that's all the questions that I have in writing. Chewy, do we have anything that was sent in?
Yeah, there's a few here in the chat, Darren. One of them is there any update on the 1099 issue?
No, we don't have any updates right now. We've got a letter from the expert that we hired that we are going to send to the trustee and his team later this week. And the goal is to get them to drop the 1099 requirement, but there's nothing to report on that right now.
Thanks, Darren. Another question here is, has any progress been made on how attorney's fees are calculated? Trotter rule or something else?
Yeah, it's not going to be the Trotter rule. He's indicated that initially he said it was going to be done on an hourly basis. There was a lot of pushback from us on that because that would not be fair to the victims. We submitted a brief 2 days ago that is asking that the amount, the percentage that's in the attorney fee contract be awarded. He's considering that, and he's asked us to go to a mediator to see if we can work that out. So that's something that we're going to be working on. Hopefully it's going to be wrapped up in the next couple of weeks.
Thank you, Jerry. There's a follow-up to that. Some people here on the chat are wondering what that Trotter rule was.
Oh, the Trotter rule was, or the Trotter formula, as we call it, is you take the economic damages, you put 50% on top of that, and then you put a reduced amount for having gone through it. So, you might put $1,500,000 and then 150,000 is how it would work. So you would end up netting the total amount of your economic losses plus something else for having gone through it. That's the way that it works in a nutshell. It's different in every case. And what he said is that there's, it's going to work a little differently here. It'll be an amount for attorney fees, and then it'll be the full amount that would be awarded for economic damages, not a reduced amount as they do it. I'm sorry, for non-economic damages, not a reduced amount as they do under the Trotter formula.
Appreciate that, Jer. Can you briefly explain the relation between the property damage claim and the medical portion of the claim and how they affect each other, if at all?
The medical?
Yeah, the
Okay.
medical portion of the claim.
Yeah. Okay, so there's a couple of things there. The questionnaire right now asks whether or not you have suffered an injury for a non-economic damage claim that you're making. And they do that to help out with taxes. But the problem is it creates another problem related to liens, and that's where all the medical information comes in. So that's something that I'm working on with the claims administrator right now. They have a team that's handling the liens. We've got a call set up for next week where we're addressing this issue, and we're trying to get the language changed so that you don't automatically trigger the lien reporting requirement. The problem is if you claim the physical injury and you had any kind of a treatment, now all of a sudden you have to list that, and there is a lien for that treatment that comes in. And if it's Medi-Cal, Medicare, anything like that, it generally takes a very long time to resolve, and no payments can be made while that lien is pending. I mean, it can take up to a year to get resolved. So that's not an additional time that we want our client staff to suffer. So we're trying to wordsmith it to create a situation where you're still free to claim physical injury when it comes to your taxes, but you are not locked in to having to make a claim that triggers this lien reporting requirement. So that's just a process that we're working on.
Thank you, Jerry. Question here is, how will the trustee value non-economic damages? How are they calculated?
There's no specific rule. What they do is they look at basically three factors. Number one is your proximity to the fire, how you left the fire, what it looked like, that kind of thing. Number two is what your life was like after the fire. Did you lose everything? What circumstances were you in? Were you in significantly different circumstances, that kind of thing. And then the third are the cherished possessions. So they look at those three components and they'll come up with some amount.
Another message here in the chat, Jer, is do you have the number of claims submitted by Singleton Law Firm to date?
Off the top of my head, I don't.
All right, Jared, that looks like that's it for the chat. You can open it up.
All right, well, let's open it up. Who's got questions from the big board?
Hi, Jerry.
Hi.
Can you hear me? Okay.
Yes.
You were talking about how the expenses get deducted from your claim, but I just wanted to be clear about and maybe this isn't even clear yet, but so you have your economic damages, and then what is deducted is your assessments, and if you're part of the Tubbs fire, that amount, your cut that you need to pay for that. But the attorney's fees are paid on the gross amount. So the attorney fee will be put on top of both your economic damages, which will then include your assessment fees. And then the attorney's fees are on all of that. Is that the way it's figured?
Yeah, the attorney fees are a third of the total amount.
Yeah,
And so the way that it works is there's let's use 1,500,000 and the costs are 10,000. So the costs are advanced, but they're paid back by the client, because typically in most litigation, clients advance costs. In these kinds of cases, generally clients aren't in a position to do so. So we advance the costs and then we recover them from the client at the end. So using the $1 million or the 1.5 million and the 10,000, it'd be 500 in attorney fees, $1 million in amount to client, and then the 10,000 would be taken out of that million.
so you're paying attorney fees on your assessments, because that's part of the gross amount, right?
Yeah, you're paying attorney fees on the gross amount.
Yeah, okay.
Jared, I do have a few more questions here in the chat.
Sure, go ahead.
It says, do we have to sign our claim before it is submitted?
Yes, so that's something that they added recently, and there are two options. One is you can sign it, or two is you can give express permission to us to sign it. And so we'll do it either way you want. Some people have said they want to take a look at it and sign it. Other people have said go ahead and do it. So it's an option that you have. Just let us know.
Thank you, Jerry. Another question here is, some of us thought this suit would be settled within the initial timeline, which we thought was months ago. What is the actual timeline?
Okay, if the question is timeline for payment, it really right now depends on the trustee. We're hoping that the initial cases are going to be paid out in December, but we haven't had any definitive answer yet. And again, that's up to the trustee.
Thanks, Jerry. It looks like Mr. Parsons has a question.
Oh, sure, go ahead.
Yes, can you hear me?
I can, yes.
Oh, good. I'm using a new earpods thing. I broke my headset, so I had to go with the original Apple. So I'm not sure how this works, but if you can hear me, that's fine. So you just brought up the fact that the claimant now has to sign the form. Now I'm asking for my brother, you know that.
Right.
I'm asking for my brother Earl. How will you facilitate him being able to sign the form?
Well, it depends on a couple of things. One is whether or not he wants to sign it. If he does want to sign it, then if he has email or text, we can set it up so that he can do that. On the other hand, if he doesn't want to sign it, then that's not a problem. We can work it so that he doesn't have to. We can just talk with him, get his approval, and then sign it at that point.
Okay. I can talk to him and reassure him that that you guys can sign it for him, but you'll have to talk to him personally for that authorization. Is that correct?
Yeah,
okay.
Exactly. We'll have to speak with him to make sure that we get his express permission to do it.
Okay. The other thing is, how will we know when our claim or his claim has been submitted?
At this point, the way that you'll know is that we will talk with you and either have you sign it or get permission to sign it.
Okay. Okay. Yeah. So, okay.
Yeah, initially that wasn't the case. They changed that recently. So now there's an easy way for people to know if, if you've given permission or if you've done it, then that's it.
Okay. Well, it sounds like the court and the trustee are continually trying to change the rules of the game during the game.
Yeah, I mean, I think what's happening, and I completely understand why people are frustrated. I believe what's happening is that there is just a learning and growing process because, again, the whole thing was set up on the fly. So we're at the point where once you get down to the actual, going through the process, you realize, okay, things have to change. And so that's why they're changing it. I don't think they're trying to make it more difficult. I think they're trying to come up with practical ways to improve the process.
Yes, but I'm still confused because this isn't the first class action lawsuit that these people have gone through.
Well, and this isn't a class action lawsuit. I think that's one of the issues.
Okay.
Yeah,
Okay.
a class action is where you have several specific classes and each person gets a set amount. Here, the problem is you have to value each one of them. And so the reason that's good is it means that everybody gets their actual damages.
Right.
The problem is you have to come up with a system for doing that very quickly. And so that's why it's taking so long.
I understand now. Okay. Yeah. All right. Thank you very much.
Sure. Yeah.
Hey, Jerry, it looks like Mike Chabatov has a question.
Okay, sure. Go ahead.
Yeah, hi, can you hear me?
I can, yes.
All right, great. So it's my understanding that our claim submitted will not necessarily have a finite amount allocated to each category of loss. And so when we get an offer, are we going to understand how it's apportioned? Because that may inform our interest in going to mediation or not in terms of how much they valued each portion of our loss.
It's unclear. There's been talk about doing it both ways. The trustee has been saying they are going to do it the way that you've suggested. The problem with that, from our perspective, is that if they do it that way, then it becomes very clear that certain parts are taxable. And so what we've said, and this is based on the experience we've had in prior fires, is, look, if you want to provide some basic amount and say, look, we valued, according to our expert, the rebuild was X, but then have a larger number that's just a global number for the entire case, that's fine. That's the way we usually do it. That way, you, with your tax professional, can say, okay, well, we believe that this was the amount for the rebuild, and we'll have documentation for you. And it gives you a lot more flexibility in terms of what you assign to certain amounts, some categories being taxable and other categories not being taxable. So that's an issue that we're still fighting about, and that gets back to the 1099s. If they do it in terms of the structures are worth X, the non-economic is worth Y, the loss of income is worth Z. If you do it that way, then certain categories will be taxable and they will issue a 1099. We're trying to get away from that.
Okay, I understand. Because also in terms of our ability to defend different elements of our claim, if there's a big discrepancy between what they've come up with and what we submitted and we have compelling evidence, it's just nice to know kind of how it was distributed so we know whether it's worth contesting.
Yeah, and there really is, there's two concepts that are in direct tension to one another. On the one hand, you want what you're talking about. You want to be able to say, hey, no, that area is wrong. On the other hand, if you do it that way, you pretty much lock yourself into a system where the trust knows what it paid for taxable things, and they're going to have to send 1099s. So what we've found is that in general, it's better to do a lump sum.
Got it. And you might be able to, from your experience, at least understand possibly kind of how it was roughly allocated and whether or not it's worth challenging.
Yeah, I mean, the thing is, once we see what the claim is and once we see what their response is, we can tell you what it should settle for. And so if you're in that range, then we say, look, here's what we think it should settle for, so it may not make sense to go forward. That said, it's up to you. On the other hand, if we're projecting that it should settle for 750 and they're at 6, then our advice would be, this is way too low, you should go forward. Again, it's up to you, but we can give you that advice.
Okay, thanks. And I got one quick other question. There keeps being this reference to proximity to the fire as being such an overwhelming factor. Well, in our particular case, we had one family member who was in it and got rescued. But on the other hand, my wife and I were 500 miles away, and we found it to be particularly devastating for us to not be there, not only for our son, but to save things that were precious to us, like our pets and all the irreplaceable items. Whereas so many of our friends who were there and could check the proximity box made multiple trips to their home and got all of their irreplaceable possessions. So, you know, is there some ability to accommodate for that kind of a difference? Because it's a huge disparity in our view.
Sure. And remember, it's what they do is they look at the legal categories. And one legal category is zone of danger. So when we say proximity to fire, if you're able to make several trips, but you're not in danger, then you're not entitled to any more money. The danger comes in where you were describing, you had the one family member who had to be rescued. There are so many of these situations where people were either, you know, by the grace of God saved, or, you know, had very near misses. That is a separate component of damages that is completely distinct from what everyone went through when they lost their house. So that's something that is going to be worth an additional amount. And I want to make sure we're clear on that. It's only for those people who were placed in danger, not just anyone who was in the town at the time the fire happened.
Okay, thank you.
Yeah.
Hey, Jerry, there's a few more submissions via chat.
Sure.
One of it, our Hartford Insurance is closing our claim within the 2-year timeline. We can't get them to extend either on content or rebuild. What can we do?
I think the best thing to do is to speak with Joel Alba. He is our insurance expert, and he can give you some advice as to how to respond. Typically, you want to respond with a letter that lays out what the hardship is. And in this situation, the insurance commissioner has been pushing for them to keep things open for an extra year. So that's language you can add in. But the best thing to do is just to contact the office, ask for Joel's information. We'll put you in touch with him and he can help you out. That's not a service that's anything extra. He works for us, so it's not an expert fee or anything like that.
Thank you, Jerry. Another question here is, were there some claims submitted before signature was required?
Yes.
Okay. We can open it up. I'm going to scroll through the chat and the email, Jerry.
Okay. Who's next?
Hi, Jerry.
Hi.
If you had a medical injury for which you were treated and had a diagnosis, and you mentioned that somewhere in your claim, but you're not claiming, you're not asking for anything for that medical, is that a good thing to do? I don't think I need to be paid back for anything, but
Right.
I thought there might be some reason I should mention that that happened.
Yeah, and that's the problem we're having with the current wording. Because what we'd like to do is to be able to say, you suffered this, but we're not making a claim. It doesn't allow us to do that with the current way it's worded. And again, I get why they worded it that way. They were trying to help people out in terms of taxability of non-economic damages. The flip side is, you know, whenever you do A, there's always a B. And whenever you take some act legally, you know, there's always consequences. Here, our concern is that the problems that are associated with the liens are going to outweigh the benefits that are associated with the other, and we can get around the concern about taxability by making it vague and just doing one big lump settlement for each person without breaking down the categories. So kind of a long way of answering your question. If we put in that you sustained an injury as a result of the fire and you received medical treatment, then we've got to answer the lien questions. And if you have Medicare or most types of private insurance, it means that they're going to say, aha, we have a lien. We want the amount that we paid to your medical provider out of your settlement. And we want to avoid that.
Thank you.
Sure.
Jerry, I do have a few more messages in chat.
Yeah, go ahead.
It's, if you already got paid out by insurance for less than coverage A limit based on the original rebuild estimates, and now you have new rebuild estimates that are higher, will the trustee pay above what insurance paid or above your insurance limit?
Okay. Two parts of that question, so let me make sure I'm precise in the answer. First of all, if you have new estimates and you did not max out coverage A, you should resubmit those right away. To answer the second question, if you have new estimates that are above your policy limits, then yes, you can recover for those. The real dispute is going to be, let's say that your policy limits are 500, you receive 400, and the new estimates are 600. I don't think there's any question you'd be entitled to recover the 100 between the 6 and the 5. The issue is, can you get that extra 100 between the 4 and the 5? And that's going to come down to whether or not the trustee believes that you have done everything possible to exhaust that. If, for example, your insurance claim file is now closed because the time period has expired, something like that, and there's no way you can recover it, then I think you have a very good argument that you should get it. On the other hand, if the insurance company has said, look, we don't believe that it's actually 600, our experts have said it's 4, and that's what we're going with, and you don't contest that, then I think it's going to be hard. So it's going to be a case-by-case basis, but I think the first step is, whether your file is closed or not, go ahead and submit it, and if you get a rejection letter, then we can submit that with your claim.
Thank you, Jerry. Another question here is, a couple of weeks ago, you stated that people over 70 would have preference, especially if they have pre-existing conditions. We were just told that there's no such thing as preference. What is the real answer?
Yeah, I mean, technically, there's no such thing as preference in terms of what the legal definition of that is. Under Code of Civil Procedure, Section 36, subsection A, if you're 70 years of age or older and have a significant health issue, then you can make a motion with the court, which entitles you to preference in trial setting. Your trial must be set within 120 days from the date that motion is granted. That's the legal definition of preference. The way we use it here, and again, it's kind of a term of art, is to say, if we have somebody who would qualify for preference if the case were still in Superior Court, then we flag that with the trustee, and the trustee has told us that those cases are going to be considered first, all things being equal. So obviously, if someone was submitted 3 months ago and yours is submitted today, then the one with the 3 months is I'm sure going to be done and ready before yours. On the other hand, if 2 claims are submitted now, one preference, one not, the preference one is the one that's going to be put to the front. So technically, there's no such thing as preference when you're not in Superior Court, but the trustee has promised us that they are going to give preferential treatment in terms of timing, not in terms of money, it'll be the same, but in terms of consideration and the order they consider it to anyone who would qualify for preference.
Thank you, Jerry. Another question here is about, is there gamesmanship in submitting claims? Is it better to be near the front of the line or near the end in terms of the trustee being more likely to make an award closer to what you submit on our behalf?
That's an interesting question. The general rule in these big cases is that if you're at the end, you're going to get more money than if you're at the beginning. Here, though, I don't know how true that's going to be because the trustee has a fiduciary duty, and I think they're going to have a pretty similar process throughout. The one exception I can see to that is that, let's say the stock does go up, and now all of a sudden, instead of having 12 or 13 or 13.5 billion, now the trustee has 15 or 16. I think it's reasonable to assume that they're going to start being a little bit more generous if they know they're going to have more money left over. On the other hand, what they've told us they're going to do, and they may actually do this, is they've told us that they've considered that possibility, and what they're going to do is they're going to build in a pro rata so that you're getting X, but if there's anything left over at the end, it will be distributed on a pro rata basis. So, you know, whether or not that's true, I don't know. Again, I tend to think that they're probably going to be a little bit more generous at the end if they have more money than they thought they'd have. but that's just my guess. And I could be right, I could be wrong.
Thanks, Jerry. Looks like Mr. Persons has a question.
Oh, go ahead.
Yes, you were just describing the process for the preferential treatment. How do you know the ages of the claimant?
Well, we have the date of birth of all of our clients.
Okay,
And so we do that. And then
Okay.
anybody 70 or over, we ask them if they have any significant conditions to let us know so that we can vet it and determine whether it would qualify under the Superior Court rules.
so in the case of my brother, he doesn't turn 70 until December 23rd.
Okay.
Does that mean that he's not going to be considered as part of the preferential group,
Yeah.
preferred group?
Go ahead.
Does that mean that he's not going to be considered as part of the preferential group?
Yeah. If he doesn't turn 70 until December 23rd, if he had a very serious condition, something that.
Oh, he does. Yeah, he has damaged lungs,
Okay.
and their escape from the fire
Mhm.
was with fire on both sides of the road, and his truck that he escaped in got singed on both sides of the truck. So there's the trauma right there, trying to escape.
Sure. I think what we'd have to do in that case is do some further vetting. So what we would need to do is get his medical records, find out what the diagnosis is, and then see what the prognosis is. The younger you are, the more difficult it is to prove. So if you're 70, you need to have very significant. If you're 90, it can be much, much less significant. So there's kind of a continuum there. Given that he is just about to be 70, he would have the highest standard that he'd have to prove. But again, it's definitely worth taking a look at. So just contact us, say tomorrow, and we can make arrangements to find out what his prognosis and diagnosis are, and then go from there.
Okay. All right. Thank you.
And by the way, that applies to everyone. If anybody is interested in doing that, just let us know, and we'll have to get your medical records, see what the diagnosis and the prognosis are, and then we can determine if we think you would qualify. All right, who's next?
Sure, I do have, it says, is there something similar as far as preference when it comes to minors with serious health conditions?
Well, with minors, there's a separate provision under Section 36 that can allow them to speed it up. I don't think the trustee was contemplating using that, but that's really a case-by-case basis. So the best thing to do is to either contact me offline or contact Erica and explain the nature of it, and then we can determine whether or not we think it is something that would cause the trustee to push that case forward.
Thanks, sir. Looks like we have a hand up. Mr. Arthur, is it Beto?
Oh, yes. Go ahead. Art, I think you're on mute. There you go. You're off now.
Okay. On the insurance issue, you have a total amount for the property damage. And I haven't submitted a personal property amount because they paid me what I thought my personal property was. Now, do you look at the total amount that the insurance company pays you, or do you separate the property from the personal property?
Yeah, that's a good question. We don't look at it in toto. We just look at it by bucket. So if you did not make a personal property claim, then your personal property monies received would not come into it. Same thing is true with ALE. A lot of people don't make ALE claims. And so when they don't make a claim for a particular category, then that category is not considered. It's only the ones that you make a claim for that are considered.
Good, thank you.
All right, who's next?
I have another question here that in the chat it says, in your opinion, when do you think all claims will be submitted? A rough time frame.
Well, I think that I think the vast majority of them will be submitted this year. I do think that the trustee is going to extend the date. Right now, it's December 31st of 2020. I just don't think that's workable. There's 13,000 unrepresented people, for example. And then there are a lot of folks who, you know, they're going through a lot and they're just not able to get their documents in. And I don't think he wants to cut anybody off. So my guess is he would extend the date by 90 days. He may extend it further, but I'd be very surprised if it wasn't extended until at least April 1st, which would be 90 days. And then, you know, we'll see.
Thanks, Jerry. I don't have any more questions here in the chat or email.
Okay. Anybody on the big board?
I have a question.
Sure, go ahead.
This is Linda, and I am confused about your statement about personal property claims.
Okay.
Farmers Insurance paid us the full amount of our insurance for personal property right off the bat. I mean, by the end of November of 2018, we had our claims met. So they did not require us to claim separately personal property individually, and now I'm confused.
Sure.
I have done a personal property list for this situation. Am I then not, was that right to do? Because we were uninsured on our personal property because I lost an art business.
Sure.
And all of the paintings and the art studio and everything else, which I believe was uninsured, underinsured.
Right.
So should I have done that? Should I have completed that claim?
Yeah, no. I think the question, and I think I see where you're going with this, and please let me know if I'm misunderstanding it. But I think the earlier question from Mr. Beato was that he was not going to make a claim against the trust for personal property because he feels he was completely compensated by his insurance. He wanted to make sure that, let's just say that was $1 million. He wanted to make sure that in looking at what the insurance offset was, the trust didn't say, well, we see here that you got $1 million for this, so we're going to deduct it even though you're not making a claim for that category. And so that's not going to happen. If you don't make a claim in a particular category with the trust, they will not offset any insurance paid. In your case, let's say, and I'm just making up numbers, but let's say that you received $500,000 for your personal property and your full claim is $1 million. You are absolutely entitled to make the full claim for $1 million, and let's say they award $750,000. They'll take that $750, they'll deduct the $500, and the $250 will be the difference. So that's how that'll work.
I understand, and that's the way I thought it might work. So that's good. That confirmed my my thoughts on that. Well, thank you very much. It's good to know.
So this is Phyllis.
Yeah, go ahead.
So in the very beginning, when you guys, I don't want to say pressured, but certainly arduously encouraged us to make a content list, we had been also paid out. And our content list does not come up to the value we got repaid. We're shy about $20,000, $30,000. I mean, nitpicking, we could say more silverware and more salt and pepper shakers. So what we're going to have $20,000 taken out of our claim now because you encouraged us to make a claim on personal properties and we didn't come up to the limit that we were paid?
No, absolutely not. If you make a list and it turns out that you did not exceed what you received, then we simply would not make a claim for that amount. Or for that category. And I'm certainly sorry that you had to do that. I know that is a pain. It's not fun. The reason we ask people to do it is because there's no way we can know if you were fully compensated until you make the list. Most times, say, 8 out of 10, people do exceed it. There are those times they don't, and I'm sorry you had to do that additional work. It looks like it was unnecessary. Again, I'm sorry that you had to do that.
And in addition to that, it's very heartbreaking to sit in front of a computer and itemize everything you lost in a claim. But thank you for that answer.
Absolutely. Okay, do we have any other questions?
I have one, Jerry.
Please, go ahead, Kathy.
On the taxes, what I'm wondering is, can that be added somehow? I mean, they're actually basically taxing us on things that they took away from us because that's the property. So whatever we get back from our settlement, and if they tax us on that, is there any way we can include in our claim, if we have to pay taxes, then PG&E should pay those taxes?
Well, the answer to that, unfortunately, is no, although I agree 100%. I mean, the way I think it should be done, and this is something that unfortunately the tax laws were changed recently to make it more difficult for victims. But the way I think it should be done is that these should all be tax exempt. So they need to modify federal and state law stating that it is completely exempt. Unfortunately, they don't do that. Now, with respect to personal property and real property, the general rule is that if you're receiving money for it and you replace what you lost, there's no taxable event. Again, I'm not a tax lawyer, but I can tell you that's the general rule. Where you get into difficulty is when it comes to non-economic damages, because the law as it currently stands states that if you have a non-economic damage and there was no physical injury, then that is taxable. And that gets us into kind of two situations. Number one, that's why the trust encourages people to make claims for things like smoke inhalation, eye irritation, those kinds of things, because then you can truthfully claim I had a physical injury. That then gets us into that whole lien issue that we were talking about, because if you make that claim and you received any kind of medical treatment, now you have to list that as part of the lien. So what we believe the proper and the best, the best practice would be is to say, don't ask anything about that. Don't issue a 1099 because you don't know, and let the individual work it out with their tax preparer. And then at that time, the individual can say, yes, I did have, obviously if it's true, yes, I did have smoke inhalation, I had eye irritation, something like that, you can claim a physical injury. So that's what we think should happen, and that's what we're going to work on getting done. But I know that's kind of a long answer. The answer to your question is, unfortunately, the law does not allow you to recover any kind of taxes that you may have to pay on any recovery.
Okay, thanks, Jerry.
Sure.
Okay,
Next question.
I have a question.
Please.
So I think it was, or I didn't ask it right in my chat. So
Okay.
Can you explain the relationship between the property claim amount and the personal injury claim amount? Do they affect each other? So for instance, if the personal injury claim amount is X, does that have a cause and effect on the other one, or vice versa?
No, they're completely separate, and personal injury is going to be worked up by a whole separate group, because most individuals are not claiming personal injury. So they're having a special team that's going to work on any kind of PI and then wrongful death as well, in determining what that amount should be. For most things, they don't need attorneys. They're having just, regular claims processors. But with personal injuries, because it's kind of specialized, they're having, I believe who they're hiring is retired PI attorneys to take a look at them and say, okay, this is what we think this one is worth, that kind of thing. But to answer your question, they are completely separate. They do not impact each other in any way, shape, or form.
Okay. And then the other question was, you talked about, I'm sorry, I think the word was preferential treatment.
Preference, yeah.
Or preference.
Yeah.
Is that applied towards someone like, a very 2-year-old or something like that? And if so, is that something that should be raised with the personal injury attorney?
Yeah, the way that preference works, the statute, section 36, is that in order to really benefit from it, unless you're phenomenally sick, you have to be over the age of 70, so 70 or over. You can get it. There's another section, subsection D, that allows you to get it if you're under the age of 70, but there you have to present clear and convincing medical evidence that you have 6 months or less to live. So we certainly hope none of our clients qualify for that. And that is a very high bar to meet. You would essentially have to get a declaration from a licensed physician saying, I've reviewed this claimant's file, and in my professional opinion, to a reasonable medical certainty, this individual's prognosis is 6 months or less.
Okay, so only under those circumstances. So not like a serious pre-existing condition prior to the fires that's very serious, that wouldn't qualify?
Again, unless we can present the medical evidence to a reasonable medical certainty stating that it's 6 months or less in terms of life expectancy, you are not entitled to a preference.
Okay, thank you.
Jerry, I got a question.
Please.
As far as insurance companies being paid out first, first of all, I don't know why they're being paid out, because that's what we pay our premiums for all the years we are in our house, to protect us. Why would they be able to recoup anything? And they should have to replace our premiums since they got paid billions of dollars back. I just kind of confused on that. Isn't that what we pay for, to be protected by them? Why do they get to collect anything?
Well, those are good questions. And the answer is, it's complicated. Let me provide just kind of a quick overview, and then let me know if this answers the question. So it used to be at common law, and this goes back to English common law before we were our own separate country. There's a concept called subrogation. And what subrogation says is that if you are an insurance company, and if you pay out damages to an insured, you are allowed to recover what you paid out to the insured as long as they are made whole, completely whole, by the third party. Now, insurance companies, being what they are, fairly rapacious, they started looking for ways to get rid of that made whole rule. And there was a case that was decided by the Supreme Court a number of years ago that essentially got rid of the made whole rule, in that it allowed insurance companies for the first time to contract around it. So when you look at your policy, most of them now have waivers of the made whole rule. So whereas it used to be that they couldn't recover unless their insureds were made whole, now they no longer have that requirement. So that's one reason. The second reason, and in terms of why they got paid first, and again, technically they didn't get paid first, we all got paid at the same time, but these cases are taking much longer to resolve because the amounts aren't liquidated. With the insurance companies, their amounts are liquidated. Farmers paid out $3 billion. So if they recovered 58 cents on the dollar, you take 58 cents of $3 billion, about 1.95, and that's what they get. That's a very easy calculation to make, whereas here everyone has different damages, and that's why this whole process is necessary, because we have to work through what those damages are.
Okay.
I know
guess,
that, yeah.
That's fine. Thank you, Jerry. I just don't understand why they get paid at all. But
I hear you, and frankly, if I could change laws, one of the big ones I would change is that made whole. I would do it back to the way that it used to be, that insurance companies don't recover a penny until their insureds are 100% made whole, and only then, after that, can they do it. But this is one of those times where I don't get to make the laws, and I'm certainly very sorry for that.
Well, thank you, Jerry. Appreciate you.
Sure thing. Okay, who's next?
I have a question.
Yeah,
I have a
please,
question.
go ahead.
What is the time process after finalizing the claim?
Okay, so once it's finalized, then the initial payment should be made very quickly. We don't know the amount of the initial payment yet because that's something that the trustee is budgeting for right now. But some amount will be paid. It might be 50%, might be 70%. They may break it into threes, in which case it might be 25 or 30%. We don't know that, and we won't know until we see what that initial budget is. But that should happen pretty quickly. My guess is within the first 30 days or so. Typically, once a settlement is reached, a claim is made, the turnaround time is very quick. So that part will happen then, again, probably within that 30 days, maybe 45, but it should be pretty quick. Now, the second part of that is not going to be paid until everything is resolved, because the trustee has to figure out, okay, what percentage am I going to be able to pay of those final claim amounts? Is it going to be 100? Is it going to be 90? Is it going to be 80? What's it going to be? And then they'll look at it and they'll pay the percentage. Hopefully it'll be 100, but we don't know, of that remaining amount to you at that time.
Okay, thank you.
Sure.
Hey, Jer, I do have an email here. It says, by law, does the trust have a set amount of time to pay out all these claims?
Not by law, but the trustee, again, the reason that he set that December 31st date, 2020, is that he wants to do it as quickly as possible. We anticipate that most funds will be paid out in 2021. Realistically, I don't know that everything will, simply because I think there may be some complex cases that bleed over into 2022. But I would be shocked if we go substantially beyond that. I think we're looking at 2022, probably the first half, as being the absolute latest.
Thanks, Jer. And another email here says, do you happen to know how much the trustee has been paid to date?
I don't. That is something that is available, but I don't have it. They do have to provide accountings on a quarterly basis to the Trust Oversight Committee. So I'll receive that, let's see, probably in October. But as of this point, I don't know how much they've been paid.
I have a question.
Please.
This is Linda again. I want to get back to that taxable payment. If we receive, how do I put this? So I lost a lot of original paintings that are not going to be, that cannot be replaced. And if my claim is paid for those paintings that are over and above what I received in insurance, I'm going to be taxed on those? I can't replace them. They're irreplaceable. Is it what? I don't understand.
Yeah,
the tax.
that is a question that, because I'm not a tax expert, I'm really not able to answer, unfortunately. So I would, because that's not something that I normally deal with. We don't have a ton of clients who have that, and I'm certainly sorry for your loss. So we can put you in touch with a tax professional, but unfortunately that's not a question I can answer.
Okay. The other question related to that is, many of the items we lost are irreplaceable, and many of the items we choose not to replace because we are going to absolutely and have been living much simpler. And we have to pack up. We've been evacuated already from 2 wildfires in our area, and we cannot mentally or physically replace items that were lost. So if we do receive payment for those, gosh, we're going to be taxed again on those. Well, yeah, I need a reference of a good tax professional.
I think it makes sense to speak to a tax professional because, again, there is some flexibility in terms of allocation. You know, you don't know what exactly was paid. And so you can look at your economic losses, you can look at your non-economic losses, and you can figure out what a fair allocation would be. And I would recommend that you do that in consultation with a qualified tax professional.
Okay, thank you very much.
Sure. All right, who's next?
I have a question.
Please.
Yeah, regarding the taxes, I'm a little stressed out about this whole business.
Sure.
So if I had you give me a reference to a tax attorney, but they would, I'm assuming, be familiar with this sort of case rather than me trying to hunt somebody down.
Right.
I mean, can I call your office, get a reference to a tax attorney, and also if I got a reference to somebody to help me set up a trust, do those attorney fees come out of my settlement, because I really can't afford to pay out of pocket? That's my question.
Understood. We can certainly, we can give you references, and then we can talk with those folks and see if they would be willing to do it on what's referred to as a lien, with the understanding that they would be paid from the settlement itself. That's certainly something that we're happy to help you out with. And I can refer you to tax attorneys, to CPAs, who oftentimes are quite a bit cheaper. But again, we do have a CPA and a tax attorney that we work with who know this area of the law intimately. And so I would definitely suggest talking to one of them.
Okay, that's who I would want to get in touch with.
Sure.
So I'll get in touch with your office then, Jerry, and figure that out now before the settlement. Is that what I should do?
You know, in terms of the tax, I would wait to see what the settlement is, because they're going to want to know what you recovered.
Gotcha.
So that generally makes the most sense.
Okay. And in terms of setting up a trust to keep my Medi-Cal coverage, would I get in touch with your office now or wait until?
Yeah, no,
Okay.
that's something you want to do now. And there is there's a firm that specializes in that we work with a lot. They're local, and so it's called Battalion Walters, and we've worked with them on a number of fires. They're very good with that.
Can you spell that for me?
Sure, but the best thing to do is just call the office, and we'll give you the information, and then you can reach right out to them.
Okay, I appreciate it.
Sure.
All right. Have a good evening, guys.
All right,
Jared,
who's next?
Another question here in the chat. It says, if a child dependent receives an amount from the PGE trust, will it be paid to the parents/guardians or put into a trust for the child?
Depends on the amount. Typically, if it's $5,000 or less, it's paid to the parents, and they are responsible for using it for the benefit of the child. Typically, if it's more, then it is put into a blocked account until the child reaches the age of 18.
Thanks, Jerry. I don't have any more questions.
Well, I have a question.
Sure, go ahead.
All right, so we've been contacted several times by your office for narratives and content information, and we've contacted your office a couple of times for minor details. Are all those times ticked against our account? Did you keep an accounting and charge us for each of those phone calls or those interviews that we do?
No. It's a contingency. So there's no, I mean, we keep track of the contacts we have. We have a file where we do that, just so we have notes. So we make sure that if you make a request, that we have a place where we have that. But no, it's not an hourly basis. It's a contingency. So you're welcome to call us or email us as much as you like, and there's no additional charge for that.
Contingency meaning I'm not charged against my award, whatever it may or may not be down the
Right.
road?
Contingency
Okay.
meaning that our fee is contingent upon us successfully recovering, and then we get a percentage of that. If we don't recover anything, we don't get anything.
Okay, all right. So it's just a flat fee sort of kind of.
Right, exactly.
All right, thank you.
I have
Jerry.
another question.
Okay, we had two people. Let's go here first, and then we'll come back over. I think it was Mr. Malone. Go ahead, ma'am.
Oh,
Jerry.
thank you. This is Linda again. I've been keeping a journal since the fire, starting on November 9th, 2018, and I journal all the time I'm spending on this, and I want to know if my time is billable to PG&E.
So that's an interesting question. The law is mixed on this. I think the general best practice is simply to put in the amount of hours you've spent on recovery. That's the way we typically do it, because some court cases have said it is recoverable, some court cases have said it's not. The way that we typically deal with it is we put that in, and then it's a factor that's considered in terms of the non-economic damages.
Okay, I understand that. Thank you very much.
Sure. And then I think Mr. Malone had a question.
Yeah, Jerry, I got a quick question. I was just
Go ahead.
wondering, anybody been paid out yet? I know you're not going to tell us
No.
how much, but I just wanted to get your feel on, like, have any claims been paid from the Butte fire? And because we're hearing everything up here, rumors
yeah.
go, like,
Let me back up there for 1 second.
go ahead.
In terms of the Butte fire, there was a special class. There were 52 cases, and we had 30 of them, and a couple of other attorneys had the balance. But for those 52 cases, they had signed settlement agreements. So their amounts were liquidated prior to PG&E declaring bankruptcy. And then once PG&E declared, they just didn't pay. So that is in a completely separate category. It's considered a different type of debt. So as soon as PG&E emerged, they had to pay those from a completely separate fund. So that didn't come out of the Fire Victims Trust. It was paid out of normal operating expenses, but only those 52 cases have been paid. And the reason they were paid is they were not paid by the trust, they were paid separately.
Okay, you don't have a feel of any other kind of claims being paid and how much and nothing like that?
No, no other claims have been paid. One of the things we've been pushing on is to try to get some emergency funds paid for people that are either in, dire straits, whether they're homeless or, on the verge of being something like that. We're trying to get some short-term payments made to people in extreme circumstances while we're waiting for this to get resolved. That's something that we discussed on our call today. I'm hopeful that'll happen, but we don't have any decisions yet.
Okay, thank you, Jerry.
Sure. All right. Any other questions?
It looks like Mr. Parsons has a question.
Oh, sure. Go ahead.
Yes, I'm curious as to your comment about Medi-Cal patients having to pay taxes on their award. I don't understand. Is that only if they claim medical expenses?
Right. Well, it wouldn't be limited to Medi-Cal patients. Taxes have to be paid by anyone who has a taxable event. So if you receive non-economic damages and you had no physical injury, regardless of what kind of insurance you have, you'd have to pay it. Where Medi-Cal and Medicare can be specifically a problem is if you have a lien. Because with private insurance companies, those liens are usually pretty quick to resolve. With Medicare and Medi-Cal, it can often take up to a year. So we really try to avoid any of our Medi-Cal or Medicare clients making any kind of claim that would trigger a lien, because the problem is once the federal government believes there's a lien, now the trust can't issue a payment until they release the lien. So that's why that becomes an issue. And that's why I'm having this call next week with Kathy and her team to try to wordsmith the questionnaire to remove that issue from as many cases as possible.
Oh, okay. Okay.
Yeah.
Okay. I appreciate it. Thank you very much.
Sure. All right. Do we have any other questions? Okay. Well, that was great.
Yes, hello?
Yeah, go ahead,
Hello.
Mr. Reno.
Hey, my name is Cliff Reno.
Go ahead.
I have property that burnt in the Atlas Peak fire.
Uh-huh.
I have several questions. One of them is, why aren't the claims being paid out in the order of the fires?
Oh, because they're being paid out according to the submission. So the trustee wants to accumulate several thousand, and then they will pay those out. And then
Who
after
determined that?
I'm sorry, go ahead.
Who determined that?
The trustee.
So the judge made the trustee the judge.
No, the judge, in setting up the Fire Victims Trust, the power was given to the trustee, who then, in conjunction with the Trust Oversight Committee, the claims administrator, and a number of other people, came up with a claims administration process.
Is that legal?
Yeah.
So it's legal for the people in the last fire to be paid before the people in the first fire?
No, everyone in the same group has to be treated equally. So the way that it works is all 77,000 claimants are technically on equal footing. And as soon as they submit their claim forms, then they'll all be processed in the same way. But the trustee can't show favoritism to anyone from any fire. So he couldn't say, for example, I'm going to pay Butte first because their fire happened in 2015, or I'm going to pay Camp last because their fire happened in 2018. He has to pay them first come, first serve.
Really? Well, I would think that would be legal. I think that I can't see how that would set. I think the precedence would be to pay those harmed first. But then the other thing is the wrongful death lawsuits.
Yeah.
Are those included in our group?
Yes.
Those? Why?
Well, because this is everyone who has suffered any kind of physical injury, property damage, or any related claim from any of the 24 fires that are in the trust.
So this put a limit on what wrongful death could be paid.
When you say put a limit, there's
They
no
could
there's
clear
no
out the
limit to
whole
this.
account if they wanted to.
What's that?
The wrongful death was a criminal act. Should be treated criminally.
Well, that's a separate issue, though. I mean, we don't have the power to institute any criminal proceedings. Only the district attorney for, in the case of Atlas.
They've already
Napa County.
admitted guilt.
What's that?
They've already admitted guilt. There is no proceedings.
They haven't
They-
admitted guilt. They pled guilty to involuntary manslaughter in Camp.
Yes.
They have not pled guilty in, for example, Atlas or any of the other fires. And with respect to the criminal proceedings, those are completely separate. They have nothing to do with the civil process.
And so should the amounts that they're being paid, correct? It's a criminal act. No insurance company would have covered it. So why are we?
Well, again, it's a negligent act. That was the basis for the plea. It was a negligent homicide, and so these would be covered by insurance.
Really? I've never heard of that.
Yeah, it's
So,
like if a drunk driver hits someone and kills them, that's a criminal act. But the drunk driver's insurance is going to pay because it was a negligent homicide.
Really?
Yeah, it's only
I can't
intentional.
believe that.
It's only
They drank
intentional acts.
intentionally.
I'm sorry, go
They're
ahead.
criminally. They drank intentionally. They are criminally convicted. They do time, and yet their insurance company pays.
Yeah.
I can't believe that. Okay, then the other question is, my property burnt. I got a notice right after the fires that the county would be sending in people to do cleanup and adding it to our tax bills. A couple months afterwards, maybe a month afterwards. Since then, I've seen several of my neighbors get bills for astronomical amounts. Luckily, I read that fine print, and I've been working at clearing my property of fire hazard since then. I'm still working on it. I have several steep canyons that are covered with burnt trees. At this last fire, in fact, this last fire, I was evacuated just a couple weeks ago. And if that fire would have came over into my place, the country club definitely would have went up in blaze, Silverado Country Club. The insurance, being that I wasn't up to state code, most likely would not have covered my liabilities on that if the fire started from my place and transferred over to the country club. Also, I had spoken to my insurance company previously on this fire clearing, and the responsibility for the fire clearing from the neighbors. I have 32 neighbors in the country club. So the responsibility of the 80-foot setback clearing. My insurance company, they had instructed me to donate my land to the county for them to do the fire clearing, because they would not insure that area or insure me for fire unless that was done up to code, and the county wouldn't let me do it to code. Now that I've been instructed by this letter that I have to remove all this hazardous waste, which is the burnt trees and stumps, all the equipment that burned, so on and so forth, I've incurred multiple expenses, and it's gone on for 2 years. I've had a couple guys working on the property continuously, supplying chainsaws and so on and so forth, and fighting with the county on one dead tree that I cut down on a neighbor's place. The neighbor complained, or leaned over the neighbor's fence, and I had to go to court. So I go into court and I bring all the rules of law and the instructions I got from the county and the state to clear the area to a certain amount, and going by those exact instructions, got fined $2,000, went to court, thought I had it beat when I showed the judge the instructions. She denied it, went ahead, fined me $2,000, and then hit me with $20,000 in court fees. So to do this fire clearing of this hazardous waste from the fire, I've incurred that $22,000 fine. Is that going to be covered in this insurance claim?
When you say the insurance claim, are you talking about the Fire Victims Trust?
Yes, yes.
It's definitely something you can submit, and it's up to them whether or not they cover it.
Okay. And then also this ongoing clearing, being that it's been mandated by the county, otherwise it would have been 10 times the cost. I mean, they took out people's dirt 18 inches deep all the way around their houses, my neighbors, and took it to a toxic waste dump over in Fairfield and back charged all these people on their taxes. I have not got a bill like that because I've been doing all my own work. I have receipts for scrap. I have receipts for dump fees. I have bills from contractors that came in with excavators loading the stuff. I have ditches that I've had to dig for erosion control. I've had your company sent out an erosion control expert. I still have not received the erosion control expert's estimate on what she thinks it would have cost and itemized so that I might be able to go through it and make sure everything was covered. So I would like to get that. And then she also said you were going to send out a forester to estimate what it would cost to clear the forest and replant it. I have not seen that person. I would like to know when I could see that person. And then there was also, this equipment. I have a bunch of storage up on a quarry I have. I have 2 registered quarries. One of them is where I kept all my equipment. At the county's orders, I couldn't store it next to my barn. I'm remodeling a barn that I had permits on, and so on and so forth. I had all the supplies and equipment to do it with and to put my vineyard in this quarry. All of it burnt. I don't have receipts for every bit of it, but what I have is a Google Earth picture before and after. I'm also an investor. I had invested in 48 golf carts from Meadowwood Country Club. I had 24 of them up there that burnt. I do demolition. So I had trucks up there full of beams that were reclaimed beams off of the earthquake projects. All the steel that I had engineered, architect come in, engineer for my barn to rebuild it, 5,500 foot melted. So those costs of having it engineered from that steel, and that steel, I don't have receipts for the exact steel. I have the old permits, but all my permits are outdated. All my environmental permits are outdated that I had done for the vineyard to go in, 22 acres of vineyard. And the erosion control is just off the hook. My barn has been flooded every year. I mean, the mud just washes down over my driveways like 2 to 3 inches thick every time it rains good. All these things, and your company told me that I could hire an insurance adjuster to come in and help me get this claim together. The cost of what the permits back then, 2.5, 3 years ago, were a lot less than what they are now. Since the fire, the Napa County has got so much more stringent, and some people aren't even able to rebuild on their properties because of the septic systems being too close to a creek and so forth. These added additions would throw out all the receipts that I already have, and I would have to go get estimates over again at this time and the cost now, especially being that everybody's working on fire properties and there's no labor. These differences, I don't even know where to start. And then I understand that if you pay on 50 cents on the dollar, then the person I hire, I'm putting out 50% of that again to help me with the claim.
Yeah, let me just say this. I mean, it's obvious that you've got a tremendous amount of losses. I think these are probably issues that we should discuss offline as opposed to with everyone on. But yeah, I mean, the majority of the things you're describing, pretty much everything I've heard so far, is something that you can claim. So I don't anticipate. I'm sorry, go ahead.
What about, I have another house that I had been working on, and it's since flooded, and I haven't been able to work on it. What about the payments and the insurance and the taxes on that place? Because I've had to focus on this fire clearing due to the fact that they're going to fine me with this, send their own people out if I don't get it done.
That's going to be a tougher claim because it's a little bit removed. I'm not saying it's impossible to make, but it certainly is going to be more difficult. I think, again, probably the best thing to do is just to discuss this offline, and you know, we can go through them specifically.
Could I get a schedule for that?
Yeah, I think the best thing to do is just you know, reach out to my office, and we can set something up.
When could I expect a call, or do I call them? Or?
Yeah, just call tomorrow, and we'll set up a time.
All right. Well, thank you very much.
Sure, no problem at all.
All right.
Okay, so do we have, let's see, it's about 6:45. Do we have any other questions for this week, or should we wrap it up? Hi, Janice. Okay. All right, everybody. Thank you, everyone, for your patience. I know it's been a long time. We are making progress. And if you have any questions, let us know. If not, we'll do this again next week. And let's talk soon. Take care.